it is submitted that this Honorable Court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so and so, so and so, so and so, where he will not be bound by the aid and advice, and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchhi Commission, and have been concurred by a 5-judge bench of this Honorable Court in Nabam Rebia. I'll read, my lord, very illuminating paragraph of Nabam Rebia, where the Constitutional Court specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Shamsher Singh. Shamsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Shamsher Singh's 7-judge bench judgment is taken note of in state of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the. It's not there, my lord. I can't, my lord. In state of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment takes note of Shamsher Singh, but it has escaped the attention of the bench of these 2 paragraphs, which according to me is the real law of them, where Shamsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Shamsher Singh versus State of Punjab, where this Honorable Court held, under the cabinet system of government as embodied in our Constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the Constitution on the aid and advice of his Council of Ministers, save in spheres where the governor is required by or under the Constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisors to bear responsibility for his action. Those advisors must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our Constitution. The Indian Constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisors to bear responsibility for his action. Those advisors must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. These two paras are quoted. What is missed from Shamsher Singh is in my written submission at page 197. These two paragraphs. Please see para 54 and 56. The provisions of the constitution, your lordship gets one. The provisions of the constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, para so-and-so, so-and-so 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers in other matters where the governor acts in his discretion. He will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My Lord, now I'll come to that, my Lord, and my learned friend also will take assist your lordships on that. My Lord, in the judgment of Tamil Nadu, this is distinguished by the Honorable two-judge bench, my Lord, relying upon a concurring opinion in this seven-judge bench judgment, my Lord. One paragraph of the concurring judgment. I'll come to that. Now, my Lord, next judgment is MP Special Police Establishment Act. Again, my Lord, 5 judges, and was not noticed by the state of Punjab judgment. Para 11, I'll skip, my Lord, the first part. First part gives the facts what were the facts of that case, which may not be relevant for the present, but I have put it for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, so and so, so and so, so and so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Shamsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. Para 54 to 56.
Which you just read.
Which I just read, which appears to have escaped the attention of the bench in State of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh issue. My lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in State of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchhi Commission's formulation that governors' discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. 151. The important observation in Justice M.M. Punchhi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchhi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchhi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. Lord, this Nabam Rebia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords.